All right, today we're cracking open a real-world case file. It's a classic showdown, a frustrated homeowner taking on her homeowners association. And trust me, this story tells you so much about how neighborhood rules are actually enforced and what happens when they're not. Let's dive in.
So, let me ask you this. What happens when there's a problem on your street? You know, a neighbor's yard is a total mess, a fence is falling down, whatever it is. You call your HOA, expecting them to handle it, but they don't. What can you actually do? Well, that is the exact question at the very heart of the story we're looking at today.
So on one side, you've got Catherine Crandall, a resident, and on the other, the Champaign Homeowners Association, basically the people in charge of her community. Now, this isn't just some small disagreement over email. Oh no, this became a full-blown legal battle that wound up in front of an administrative law judge.
Yeah, see, Miss Crandall didn't just write an angry letter. She filed an official petition. That's a serious legal move, and it was designed to do one thing: force her HOA's hand. Her argument was simple. The association wasn't doing its job, and she wanted a judge to order them to do it. So what was she so worked up about? Well, it wasn't just one little thing. She came to the hearing with a list, a detailed list of 6 specific complaints against the HOA. So let's take a quick look at what was on it.
The list was pretty wide-ranging, you know? There was an issue with an unapproved garage door paint color, complaints about poor landscaping in the common areas, a fight over her satellite dish, some problems with an insurance claim, and, of course, a request for legal fees. But it was that second one, the neglected property on Lot 40, that really became the main event. And this is where the whole case really gets interesting. The absolute core of Miss Crandall's argument, the thing that started it all, was this neighboring property, Lot 40. She claimed the HOA had just let it fall into a pretty serious state of disrepair. And according to the case file, the situation over at Lot 40 was, well, it was bad. We're talking complaints of stagnant water sitting in fountains, mold being discovered on an inside wall, and just a whole bunch of violations of the community's own rules. For Ms. Crandall, this was a clear-cut health and safety issue, and she felt the HOA was just looking the other way. Now, to be fair, the HOA wasn't totally asleep at the wheel. The record showed that back in 2004, they did start sending letters to the owner of Lot 40. They even imposed some fines, but nothing really happened. Eventually, the property was sold in a foreclosure, and thankfully, the new owners started fixing things up. But for Miss Crandall, what the HOA had done earlier just wasn't good enough, not even close. Okay, this is the whole ballgame right here. Miss Crandall argued that the HOA had a legal duty, a responsibility, to use everybody's fees to go in, make the repairs themselves, and protect the health, safety, and welfare of the residents. But the HOA's entire defense came down to a really specific, really important legal distinction. They said, hey, our rules give us the right to make repairs, sure, but they don't say we have an obligation to. And boom, here it is. The proof was right there in the paperwork. The judge looked straight at the community's governing documents, the CC&Rs, and this clause says it all. It grants the HOA the right to go in and fix a property, but, and this is the million-dollar part, it does not impose an obligation to do so. That one little sentence basically became the linchpin for this entire case.
But hold on, before we get the final verdict on that neglected yard, what about all those other issues she brought up? Well, as it turns out, and this happens all the time in legal cases, most of them just kind of got resolved or dismissed without the judge ever having to make a big ruling. Let's see how they all shook out.
And as you can see, most of these complaints just kind of fizzled out. The whole paint color dispute, both sides agreed to just drop it. That order about the satellite dish, the HOA just took it back, so the problem vanished. They even agreed to help pay for the insurance claim stuff. The only thing the judge formally dismissed was her request for legal fees, because that court just didn't have the power to award them. And just like that, poof, 4 of the 6 complaints were off the table.
So that just leaves the landscaping complaint. And on that one, the judge basically said there wasn't enough evidence to prove the HOA's whole maintenance plan was a failure. But in what you might call a small, practical win, the HOA did agree right there in the hearing to take care of the one specific thing Ms. Crandall had pointed out, a broken branch on a tree near her house.
So with all those other little fires put out, it all came back to the big one, that neglected property on Lot 40. Did the HOA have a legal duty to step in and fix it? All right, let's get to the judge's final decision and the super important lesson that's in it for all of us. The entire verdict really hinged on this one simple difference. A right is like having permission. It's an option, something you can do. But an obligation is a requirement. It's something you must do. The judge ultimately decided that the HOA had the option to fix Lot 40, but nothing in their own rulebook legally required them to, especially when you think about the high cost that would have been passed on to all the other homeowners.
And so the final score was pretty stark. After all that effort and a list of 6 formal complaints, the number of official judgments that were ruled in favor of Catherine Crandall was a big fat 0. Now sure, some issues got resolved through agreements along the way, but when it came to a formal ruling from the judge, she didn't win a single one.
So, what can we all take away from this? Okay, first, and this is a big one, actually read your community's governing documents. Know what's in there. Second, pay super close attention to those 2 little words, right versus obligation. They are not the same thing, not by a long shot. This case proves that your HOA often has a lot of wiggle room in how it acts. And finally, it's a good reminder that a lot of these disputes get solved by people talking and agreeing, not by a judge banging a gavel.
Which brings us to one last really big question to think about. Go look at your own HOA's rules. Are they written to create obligations that actually protect you and your property? Or are they written mostly to give the association rights, protecting them from having to act? After hearing this story, it feels like a question every single homeowner should probably know the answer to.